Greetings and welcome to this lecture on Irish criminal law considering theft, burglary, and aggravated burglary. Legislation governing robbery is the Theft and Fraud Offences Act of 2001, Section 14, which directs that robbery is an offence in Ireland. Aggravated theft is robbery, and it is theft that is via force or threat. In Dawson and James, the force used in robbery shall be addressed as an objective test. There will be a common sense approach as to the degree of force used. A shove or an imbalancing may be proportionate, so as to satisfy the court that it is indeed a robbery, rather than the necessity of a punch or a significant push. In the Hale case, the tying up of an individual was deemed by the courts to be an application of force, and therefore it was deemed to be a robbery. The DPP in Mangan case directs that force may be indirectly or directly applied. In this case, the window of a car was smashed, placing the occupants of the car in fear. The smashing of the window was deemed by the court to be an appropriate level of force displayed so as to satisfy the threshold of Section 14 of the Theft and Fraud Offences Act to declare the crime as a robbery. The Clouden case directs that snatching is not a robbery, it's merely theft, as the force is significantly different to that of grabbing or dragging in the action of snatching. In P and others, assault during theft is robbery, as the individual is applying a force. The individual also leaves the victim in a fear of force being applied. There may be a further hailing of blows. Burglary is governed in the Theft and Fraud Offences Act of 2001 under Section 12. It directs that burglary is trespassing in a building or structures so as to commit an arrestable offence. Section 13(1) directs the offence of aggravated burglary existing in Ireland, and Section 15 directs the implements associated with offences in the Act. In the Skivington case, burglary may be defended against if there is a claim of right. If the individual is of a genuine belief that the item taken is under their ownership, this may be a defence. In the King and AG case, the burden of proof rests on the state to prove all aspects of aggravated burglary, inclusive of the unlawful entry into a building or structure. Its aggravated nature, aggravated by violence or use of a weapon or an implement as directed in Section 15 of the Theft and Fraud Offences Act. And furthermore, that the individual is beyond reasonable doubt as to have commissioned such an offence. The DPP in McMahon case directs that trespass is an offence where the individual has exceeded the purpose for which an initial invitation, if any, was given. In the Boyle and Collins case, entry via fraud is trespass, and therefore, in the circumstance of pretending to be a technician so as to fix a service in the Boyle case, and so as to the individual scaling a window under the pretense of being in a relationship with one of the occupants of the property is a fraud, where untrue, and therefore can be constituted as trespass. If the individual continues to remove items, they may be charged further with burglary. And if the individual makes use of weapons or implements as declared in Section 15 of the Fraud and Offences Act 2001, the individual may be charged with aggravated burglary, or indeed if there's any violence used. The O'Leary case directs that in the common law, an individual commissioning burglary, once armed, is an aggravated burglary. In the McCalla case, forgetting a possession being in one's possession, or the implements as directed in Section 15 of the Theft and Fraud Offences Act 2001, being forgotten about, is not a defence from their use, and the individual may not rely on such a defence to thwart a charge of aggravated burglary. They may not reduce the charge to burglary on such a defence.